এয়ারপোর্ট এসে যাবে, এসে গেছে।
Item number 1. Order.
With 7, the timing of issuance of this letter 7 is not mentioned therein. Not a fact that Exhibit 7 was prepared thereafter for the purpose of this case. Not a fact whatever I have deposed in my evidence in chief regarding search and seizure in this case is all false.
So no direct any suggestion, no any cross-examination
No
with
direct.
regard to the entire paragraph that computer generation printing
Yes,
UPC was not there.
Yes, madam.
So it dims the admittance. No suggestion was given to the witness with regard to the computer generation CPU monitor was not present at this spot. And even no suggestion was also given, no cross-examination was made on this issue. So this
And
is
my lord,
under no challenge.
In reply.
You
These are
note
the
it down,
queries.
you note it down.
Queries of the court in reply you give.
My lord, another thing your lordship will kindly consider during the evidence in chief and cross, there was no suggestion as to the identity of the house. It is a brilliant afterthought, but brilliant. Like a fantastic shot taken at the goal which sails over the crossbar.
And if that is the situation, they should have raised this issue before the trial court at initial stage.
My lord, since yesterday I was trying to
If
impress
I do
upon
not
you.
belong, the house is not belongs to me and something recovered from there. So I must indicate that yes, that house is not belongs to me.
Absolutely, and my lord, the case that has been made out here, it is not a case where no seizure, the entire seizure has been impugned, no seizure was made. They are saying, yes, seizure was made, but that is improper.
Where from you are getting that seizure
There is
was
no
made?
direct denial or direct question to that effect. The seizing officers cross I have read out to my lords. There is no such suggestion even.
That from that premises, nothing was
You see, did not seize
recovered
anything.
or seized.
My lord, then one question would be very pertinent. The premises from where you seized did not belong to the accused. Number two, you could not or did not or could not have seized anything because there was no contraband. And if it was, it did not belong to you. There is no such case made out in the correspondence.
No, their case is that house is not belongs to me and I was not arrested. Seizure was not
Exactly
seized
that.
from his
There was-
conscious position.
There
That
was
is
no
your
possession of any contraband. No
Please,
conscious
please sit
possession
down,
of-
sit down. We
That
will
was my case.
clarify, or you clarify later on.
The my lord, appellants were trying to fight into the judgment of the learned trial court, but I am sorry to say they even failed to make a tip master. As I was trying to impress upon my lord, that there might be some discrepancies. But all discrepancies does not vitiate the judgment of the trial court.
Or whether those discrepancy will touch
Go to the root
touch
of the matter.
root of the matter.
Because had been the case that the learned trial court, in spite of the IW's reselling from their statement or refusing or failing to identify the signatures, had relied on those two evidences and come to a conclusion, we could have understood. But as I was showing your lordship from yesterday, well, paragraph 7 onwards at page 30, internal page 30. I stand corrected, my lord, page 31. May I lead out, my lord? Must you got it? Now let us dwell upon the evidence of the independent witnesses of this case. PW3 did not support the prosecution case as he categorically stated that he was unable to recall an incident in connection with this case and did not know anything in this case. He also refused to identify a signature on the notices issued under section 50 of the NDPS. And on the search comes Caesar list, but he identified his signature on his voluntary statement, which signature was marked as Exhibit 13. In his cross-examination by the learned defense counsel, he stated that he had signed on the same page, which was his statement. It was completely blank. Thus, it is evident from the evidence of this witness that he clearly did not support the case of prosecution case, any bit, for which he was accordingly declared hostile in the prayer of the prosecution. PW4 stated that he was forcibly made to sign on the paper by BSF personnel at their camp in Gopalpur on night of 22/1/22. Although he managed to identify his signatures on the two notices and the such cum Caesar list, which were consequently marked as Exhibit 9.2, Exhibit 9.3, and Exhibit 10.1 series, the same was of no value as this witness denied the signature that he made these signatures in the house of Prasanth Mondal. In his cross-examination, the witness stated that he put all these signatures in the BSF camp, which all clearly shows that this independent witness too did not support the prosecution case. Now, the trial judge has clearly come to the conclusion that the evidence of these two PWs or IWs, whatever we term them, does not help the prosecution. Then, my lords, PW 5 and 1 was the two standing witnesses upon which the trial court, and PW 5 is the seizing of. I read out to your lordship right now, Raju Mukherjee. So, my lord, certain things are now emerging, my lord. First and foremost, there were 690 kgs of ganja. And my lord, we know that even keeping or storing ganja is an offense. Secondly, the appellants, by filing this appeal, has established that the premises belong to them. That apart, my lord, if we take the evidence of Birendra Mohan, the gazetted officer, that is PW. Now, my lord, PW6. He clearly says, I then approached two villagers to my lord at page 35 of the paper book. Twelve lines from the bottom. I then approached two villagers to find out house of Arjun Mandal in the said village, and they led us and showed the house to me from a distance. Now, my lord, the court of law also takes into account common actions of a man, normal action. Even anybody, my lord, any person with a reasonable thinking, if he wants to locate a house that he or she doesn't know, the first thing human psychology will do is to ask a resident of that area to show that particular house. Now, no suggestion was given that you did not go to any villager and no villager showed that house to you. So, my lord, the challenges that were raised by the appellants, one by one, has been shot down by the judge. My lord, there might be one or two I was trying to say. And my lord allows me to give an example by borrowing few lines from a famous Bengali literate, Tashangar Bandyopadhyay. Once he wrote, Mukti maje mukto jokhon janmo neয়, তখন তাতে একটা দুটো তোল থাকে, কিন্তু রত্ন মাঝে মানা হয় বটে, কোনো সন্দেহ নেই তাতে. So when a pearl is born inside the oyster, natural pearl, it will have some dent. And a cultured pearl will perfectly down. So the real judgment of the trial court will have some dents, which will come from the ferocity of the defense. But whether that dent has broken the backbone of the judgment, that is what we have to see.
One thing create some doubt in my mind, that one officer said when we knocked the door, Arjun Mandal came out. And another officer said, when we knocked the door, Prashant Mandal came.
No, my lord.
Please clarify this.
My lord, it is not that. Let us read.
Because this
My lord, I was
witness has
keeping this
said,
because it will take some time.
they knock at the door of house of Arjun. I asked the person whose answer of the door is name, to which he replied that his name was Arjun Mandal.
Which one, my lord?
And in page number 35.
Lordship.
Similarly, if you go to the page number 16,
Lordship. Page number 60.
page number 16,
60, my lord, it is 330.
16 or somewhere else. Can you assist which page
My lord,
number? It
Yes,
was,
my lord. It is,
officer mentioned that when we knocked the door, the person came out, his name was Prashant Mandal,
PW2, my lord, page 16.
16, no? Page 16, yeah, page 16.
At about 6:15 hours, we have knocked the door of the house of Prasanta Mandal. As per our information, one person having aged 29 opened the door and disclosed his name, Prasanta Mandal.
How you can clarify this?
My lord, one thing is for sure that there were two persons. So it only goes to show the presence of the person, accused person.
Both were present
were
and
present.
both may come.
This is not a discrepancy, my lord, that denies the presence of another accused or absence or obliterates or about the other. There were two persons.
No third party there, Arjun and Prashant, and
Arjun
both
and-
are implicated.
Both are implicated.
Both were inside the room. That is your
But
answer.
my lord, if instead of Arjun and Prashanto, he had given a third name, obviously the
Then
court
that
would have
would
found
be-
very seriously. So my lord, I don't want to waste the valuable judicial time of the honorable court. I only rely on one judgment of the apex court, and because my lord, the honorable judges of this in this judgment has considered a lot number of cases of the honorable apex court, including yesterday, my lord was referring, my lord, honorable Justice Gupta was referring to Baldev Singh. It has also been discussed. So instead of me interpreting a judgment, provision of law, it is better that we borrow from the honorable apex court.
That
And
is
my lord,
clarified by various judgments from the Supreme Court, High Court.
my lord, actually now there are plethora of judgments on NDPs coming from the apex court because this is on the rise. So, you might listen to it. Thank you for the- My lord, the respondent NCP raised their arguments and pray before this honorable court to dismiss the present appeal and uphold the trial court conviction.
Yes, the appellant, your reply, please.
Well, these are the judges.
One of my learned friend is very unhappy. He says, I told him 690 kgs of Gada. He says, I did not get anything.
Well, these are the judgments.
After the
Let me start with first the address, which Mr. Majumdar has repeatedly stated that in the cause title of the appeal, the addresses mentioned is same as the premises from where the contraband was recovered. Now, it is obvious, my lord, when in the FIR, the address is mentioned at XYZ, I cannot change it whimsically. And moreover, when this address has been recorded. It is not denial that there is no such address. It is the denial that there was any recovery from that address. It is the case of the appellant that there was no recovery, and entire seizure list was prepared in the office of camp battalion camp of the BSF, not in the premises, not anywhere else, in the battalion. That
Where
is if,
this case made out in the learned trial court.
my lord, since the witnesses has stated,
They
one of the
turned
witnesses
hostile,
has
they
clearly
turned
stated
hostile.
that
It
he
is
was
not
made
that-
he was made to sign on a blank seizure list which was there in the office of the battalion.
Can anybody realize that now, even in nowadays, a person can sign in a blank paper?
My lord,
They are illiterate.
if police
If
police
produce
takes someone
anything?
from the bazaar
No, but then a case
and
has to
detains
be
him
made
for
out.
2 nights detained, obviously,
One
Where is
person-
that case made out? Show us.
my lord, the first point which Mr. Majumdar raised, that the premises belong to these two people, Arjun Mondal and Prasanto Mondal. I'm replying to this first point, that there is no evidence apart from the evidence of the BSF personnel or the NCB team, not a single witness to testify that there was any recovery from that premises. First, kindly note the time of the search and seizure. It was in the early morning, after 5-6 a.m. It's a village.
These facts are already discussed.
My lord.
or already submitted.
Yes, my
Why
lord, these are-
repetition?
No, what he
Only
stated,
Give the
if-
reply on law point.
my lord,
or whatever
I'm replying to
any
his point.
is, yes.
He said that out of 10, if 2 turns hostile, the testimony of the 8 will be taken now.
Definitely. If suppose four witnesses are there, 2 public witness, 2 official witness.
My lord,
And
in
if
that
the tri-
case,
if the
in
trial
that case-
court discard entire evidence of the 2,
In that case, my
Public
lord, then
witness.
Rico Basu will not be
court-
followed.
Court will consider only those which was relied by the trial. If the trial court has already discarded that 2,
Trial court relied upon
already discarded
PW
both the
2 and
both the
5.
witnesses. Apart from that, the trial court relied other 8 witnesses and convicted you. Now you have to confine with the 8 witnesses. Why you are asking about the witnesses which was discarded by the trial court? Even we discount those 2 witnesses. You have to confine on 8 witnesses,
My lord.
which was based on for conviction.
Well,
Because 2 witnesses has been already discarded by the trial court. It was pointed by other side. It's number 35. Both witnesses has been discarded.
if the independent witnesses are discarded, the entire prosecution
Fails.
fails, my lord. Because the very
So your
purpose of
case
DK
is-
Basu was that
Your
No.
only case is that entire seizure was made in the office of the
yes,
NCB
my lord.
and entire contraband goods was there. Nothing was recovered from the.
I'm
Arrested.
coming to that, my lord. I'm coming to that. First, my lord, the prosecution had relied upon 2 witnesses, which Mr. Majumdar said, PW2 and PW5. Both witnesses has so many discrepancies in their statements. Now coming to my lord, PW2. Kindly, what Mr. Majumdar said, first, my lord, page 16. Who opened the door? PW2 said, Prasanto Mondal opened the door.
That answer was given. Again,
No, my lord.
repetition. Facts cannot be repeated again and again.
No, my lord. The answer was not clear
We
because
already put.
if it is Prasanto Mondal has opened the door, then it is Prasanto Mondal only. He cannot be Arjun Mondal.
We have noted down that
Second,
point.
my lord, what he has pointed out, page 17 from bottom, my lord, is 4th paragraph.
No cross or no suggestion. Please give me whether any where you have put suggestion or made cross on the issue of computer and printing was brought to the place of seizure, and they had printed out and they obtained signature.
My lord,
Upon
more
this
point.
issue, whether any cross made from your side in any witnesses, those witnesses have stated this fact, or any suggestion were given. If those questions are not put in cross examination and no suggestion has been made, what is the law in that case?
my lord, kindly. for
That
once-
is, you give the
I'm
answer.
coming to that. my lord. I'm
Satisfy
coming to that.
ourselves.
I'm coming. He has stated many points, so I have noted it down.
Yes, please, one by one,
Yes,
you
my lord. Kindly. my
just
lord.
don't repeat.
No, I'm not repeating, my lord.
Yes.
The first 28 labels for 28 gunny bags was signed by Prasanto Mondal because he was the owner of the said gunny bag. There is no suggestion that from where this information came. That he is the owner of that 28 gunny bag and another 28 bag, 21 labels, bags were owner of, the bag's owner was Arjun Mondal. I don't know from where this source information was received. That whose bag was this and whose bag was this. When the entire story is that they entered and found a sacks of bags were there, or the contrabands were lying. I don't know from where this source came. What Mr. Majumdar said that it has been stated Prasanto Mondal and Arjun Mondal. That I differentiate here. Second, my lord, is that page 18, my lord. Page 19, my lord. Sorry, page 19. The suggestion was given where the answer to that was the IO of this case did not seize the train ticket by which I came to Kujbihar from Kolkata. The train ticket was not handed over, not seized. So whether any NCB team came from Kolkata, that is unknown. That suggestion was taken, which Mr. Majumdar said that it was not taken. It has been answered here. Second, my lord, I did not take any steps to ascertain the ownership of the said house. Suggestion taken. He has stated that he had not taken any steps to ascertain the ownership of the said premises. Third, my lord, the signature of Ajit Biswas was obtained in my presence. That is impossible because Ajit Biswas was not there. I returned along with. Yes. I returned alone straight away from the house to the office of the BSF 47 PM at Gopalpur at around 12:31 PM. I received the said information on the relevant date at around 8:15 PM, after which I informed the matter. That is not. Now, my lord, PW5, page number 24. Now, my lord, 24. PW5, which he relied upon.
If he keeps on repeating facts, Mala, then it's difficult for us.
No. You stated that. I have noted.
You said all facts, I submitted all facts.
Yes,
I
the
think
facts
you
I'm
have
clearing
started
out.
One law.
That will clarify by the court. You should not repeat. Only the law point is required while you are replying. Otherwise, never ending process.
Number in PW5 process, he stated he is the IO of the case. He was not present on the spot. He was never present on the spot. Then how his testimony has been considered by the trial? He has stated that he has received the information at 8 AM after the search and seizure was over. He received the information at 8 AM in the morning. And thereafter he went to the spot.
But if Mr. Kumar relies on this statement, then he is admitting NCB team was there.
Yes.
If he relies on this
No,
statement,
yes.
then
I'm
NCB
admitting
team-
NCB team has gone after 8 AM. After 8 AM. So they cannot be considered as witnesses. They cannot be considered as witnesses. They cannot be considered as witnesses if they go after 8 a.m. There was no NCBT. And moreover, they have to prove that they have gone from Kolkata to Calcutta. They have not handed over anything to the IO. Then how it is proved, my lord, that there was any NCB team? And moreover, the IO himself states that at 8 a.m. I received the information and thereafter I went to the spot.
Okay.
I've gone there, everything was already complete. I found the witnesses standing there. So how it is possible? The story itself is doubtful. Now, my lord, what the my lord has come out from the mouth that regarding this my lord has asked
Is there any suggestion or cross-examination with regard to the printer or something else?
oh my lord, printer, since the
Because the
witnesses-
prosecution case was, you raised the question that how on the spot a typed copy of seizure list can be prepared. And how typed copy can be signed at the spot by the seizing witnesses. That answer was given by the prosecution that they brought the printer and they print out and signed there.
fairly submit
Obtained.
that.
So
that
there
suggestion was
is
not
no
taken, my lord.
suggestion,
No,
no cross-examination. Can you show from entire evidence some suggestion was given on that issue or not? That only we want.
Regarding printer, my lord, no suggestion
No
was.
suggestion was. Okay. Now come to the judgment.
We went on that 41B.
Hmm.
We stressed upon the 41B, section 41B of the
Yes.
CRPC that independent witness is crucial in such type of search and seizure after DK was my lord. Because the arrest VCS if the independent witness does not corroborate the story of the prosecution and the team members of same prosecution cannot be taken into testimony because they will say the same
Do
thing.
you
But
have
here, my
any
lord, there are
authority on that
discrepancies between the
issue
members
that
only.
only on the basis of two witnesses, that is seizure witnesses, if
Seizure-
declared hostile or did not support the prosecution, the entire case will be better.
My lord.
Do
Then
you
the
have?
other two witnesses on which they have relied, they also are, their statements are contradictory. Their statement also is contradictory. Then how their statement will be taken?
Okay, anything more?
PW2 and PW5, contradictory, my lord.
Anything more?
My lord, thereafter, my lord. Now, my lord, the. My lord, that's.
Okay, anybody else?
Lord,
State?
I thank you, Lord, for giving me patient
Okay. Hearing concluded. State. Hearing concluded. State. अच्छा हाँ लिखो ना एनसीबी फाइल द रिटन नोट्स ऑफ इट्स टेकिंग
Thank you, my lord. Thank you, my lord.
সেলাই করুন
আমাদের কপি আসতে
ওই
It's a copy charge superintendent আছে, হ্যাঁ এটা?
I don't know, three.
Hello, time for the appeal. Well, this is a POCSO case. The documents are
Petition has been submitted in her support, requesting she to be considered for the FPS license. However, despite of such submission, no favorable action was taken by the authority in her favor. Thereafter, the applicant was requested to submit in favor of her
What
claim.
is there to show that these two people had criminal antecedents?
Yes, Mala. That I have already submitted before the
Show
authority.
it. You must have annexed it over here.
Yes, Mala. I have one document, Mala, regarding their involved, Mala, criminal activities, Mala. They are also admit, Mala. You should kindly come to Mala, the order, Mala. State also submitted that, but their submission that they are not convicted.
Obviously,
But
there may be so
but-
many allegations.
allegation means what? FIR, Mala. FIR, Mala.
If I
Criminal
but
case-
it is till the conviction is there, how can you say that they are
Criminal
involved?
case is pending, Mala, NDPS, Mala.
Where is the bar? Where is the bar? Is there any
Until and
bar?
unless conviction, how?
Bar is that,
accused-
Mala, if,
accused can be
now, Mala,
declared.
there are several judgment, Mala, Supreme Court. If any person, Mala, this has taken anti-nation activities, they are not considered any public distribution system, Mala.
Where is the anti-nation activity?
And this is a NDPS case, Mala.
That is pending.
Yes,
No
Mala.
conviction.
But their Mala, case is pending, trial is going on,
It
Mala.
hardly matters.
But that is also one Mala. But other point is, Mala, no affidavit in opposition, Mala, or other things, Mala, has taken considered by the trial court. Only
What
just
is the affidavit? You make out a case.
Only just no, Mala. At first, Mala, they are, Mala, Justice Raja Bashir Chaudhary case, Mala, you should kindly come to Mala, order, Mala. Their re-inquiry has taken up consideration, Mala, at first, Mala. And then, Mala,
Says the word conviction, lordship. So there is no conviction. If there is any case, there.
conviction is a long-term
Any
process, Mala.
suppression was made from their side in the form.
Petition
No,
has
no.
been aggrieved by
There is
the order
no-
No declaration has been made, Mala. They are suppressing all the things, Mala.
March 2026 has prepared the instant appeal. The matter relates to grant of FPS license. The allegation of the petitioner is that license has been granted in favor of applicants against whom criminal cases are pending. It has been admitted by the learned advocate representing the appellant that the criminal cases, that the recommended candidates have not yet been convicted in any criminal case, but the criminal cases are merely pending against them. Submission is that the allegation against the recommended candidates are very serious and the same comprises offense to the nation. Stop paragraph. Learned advocate representing the state respondents submits upon instruction that the recommended candidates have not been convicted in any criminal case till date. Stop. We have produced the order passed by the district controller, Food and Supplies, Kuch Bihar, dated 7th November 2025. Stop. It clearly mentions that the appellant was unable to show any document regarding conviction of the recommended candidates in criminal cases. Stop. By mere involvement in a criminal case with no conviction, the recommended candidates ought not to be debarred from participating in any procedure for grant of FPS license. Stop. We are not convinced with the submissions made on behalf of the appellant. Stop. No case has been made out for interference with the order passed by the learned single judge. Stop. The appeal fails. Dismissed.
Can you also
Stay.
discuss?
Stay is there, dismissed.
And for the petitioner, Lordship. Lordship, on the last occasion, affidavit of service for restoration has already submitted, Lordship. And I've also informed the other side on your direction.
Union of India,
Yes,
I'm
if
bringing
there
for,
is no delay after, then it will be allowed.
no delay.
no, your Lordship.
When was it dismissed?
21st April.
21st of April.
Yes, 18th.
You are challenging what?
Lordship, I'm today only praying for the restoration and kindly fix it any day next week.
Why
Doctor,
don't you press the main appeal?
Lordship, Dr. Ujun Chaudhary will be appearing in the matter, Lordship.
According to the report of the post, must have been to the tribunal. How can this be done over there?
Employee of Department of Post Office.
Oh, Amana. Please bring your senior.
Lordship,
Where is
he's
he?
in courtroom number 5, Lordship.
Let him come. We are passing it over.
Great for that.
So they will plan to pass over.
I don't know, 6.
Lordships, before my learned senior will start, I'm one of the respondent, answering respondent. Lordship, I have not yet received the instruction. Let the matter come up in next circuit, kindly. Next 3 days are continuous holiday for bank and it's not possible by that more time.
What is the matter about?
Material Lordship, I am the one of the director as well as the shareholder of the respondent company. Other private respondents are also the directors. Allegation is that my signature has been forced by the other directors and I have been removed from the company. Thereafter, specific complaint has been lodged and the FIR has been started and the charge sheet has been filed under section 420, 465, 467, 468, 471, 120B of IPC, page number 27. Thereafter, I was compelled to invoke the jurisdiction of National Commission of Law Tribunal, page number 30.
Has your delay been condoned?
No,
Not
13 days, no? 13
There
days.
is delay. It is required to be condoned.
This is the second round before the trial court. First writ application was there and the specific direction upon the State Bank of India to consider my
Who are you
representation and
representing?
give the
State Bank
statement.
of India.
Only I am seeking for the statement.
I am the answering respondent. Kindly allow
There
me
are
some.
private parties
Yes, I am
also.
representing the private respondent.
All the-
Fit way, yes.
Allow us some time to go through the brief.
I am praying before the banking authority to provide me the statement of the company. As because I am the director, as well as the shareholder. The branch manager and the other officials, they are also in connivance with that Commission of Appeals. They are not giving the statement with the plea that the matter,
All right, since there is a prayer, Pradeep, condone the delay.
At least delay.
List in the next circuit.
delay may be condoned, Lordship.
Lordship, I have to put objection on that also.
13 days delay, what objection?
Lordship, there is no
13
specific
days.
13 days
Condition for delay has been given.
Yes, yes.
That means
Another can is there.
Only for the delay application, how can I go through the full appeal?
We are hearing only delay application, so only
What
on
is
that
the-
one.
what is your objection?
Lordship, there is no specific reason for stating so.
Ill health is there. Paragraph number
Medical,
3.
medical paper is not
Please.
given.
No, this is, please do not transform the High Court to the trial court. All right. Delay is condoned.
Lordship.
can disposed. Appeal will appear in the stay application is there?
Stay
Yes, my
petition.
All right. The stay application, the appeal will appear in
Can
the
do.
next circuit.
Can do.
Next circuit.
Deeply, Lordship.
And has Wakalatnama been filed?
I'm for the authority, State Bank. Company.
I have served the can do also.
I have to file.
Yes.
I have served. If required, I can give it to you again.
Wakalatama in the department prior to the next date.
Very good.
মানে can the state
Deeply.
Union is the appellant in this case, my lord.
Yes.
But there is two defects, my lord. One is, my lord, by inadvertence, he immediately impeached certain parties who were in the, for the.
Red court.
Red court. And limitation is there. So, my lord, I humbly pray for a leave.
Has it been served?
No, my lord.
But he
Appeal
has
has not
served.
been admitted.
It has not been served.
Please serve.
There
My
Let
lord,
a copy of the
after correction-
appeal and the application be served. After the correction. Wait 1 minute. Where is the?
Actually, my lord, the report has come from the office where it. Actually, we have already prayed for it. It is controlled.
Then you have to file a supplementary also.
No, we have asked for larger.
More. How many days you say?
82.
Oh, it's 68, then it covers. And name of the opposite parties, Acha, defects pointed out by the stamp reporter may be corrected. Service to be effected, next circuit it will appear. Eight তো কই গেল?
7.
আচ্ছা, 8.
Actually, item number 8 and 20, I'm paying for, this is matching the Wednesday, Lordship. Janet Senior Mr. Bohan is to appear. He came to Siliguri, but his, it is certain medical emergency, he went back yesterday. Lordship will be traveling, on Tuesday. Again, I'm paying for this till the month of May.
See, last day it was adjourned.
That was
30th of
first
June.
time it was appeared, yes, Basha.
Today again you seek adjournment.
My Janet Senior appeared, reached in the Siliguri, Lordship.
If your senior is otherwise unable to come, you should have prepared yourself.
She can, I'll get the note to the RD.
You cannot pray for adjournment on such mechanical grounds, especially when it was adjourned on the last occasion.
Gross violation of natural justice, even the Red Court has violated the natural justice.
Why?
If this case does not solve the conscience of the division, then which case will? Can have my lordship for a moment. I mean, the order is obviously there, black
Yes.
clouds and thunderstorm and everything. Other than that, if I can have my lordship for a moment on, just to show the conduct, on page 117 of,
Are you referring to the impugned order?
no, my lords, mat 56,
Page 56,
can 2,
can 2,
170.
117.
In
Yes.
this case, what happened, my lord, that my lordship was of the opinion that the petitioner should be made aware that their case are listing on a daily basis and yet nobody is appearing. Petitioners, they usually appear with a team of 5 lawyers. So the lawyer appearing for the revenue personally messages the lawyer of the petitioner saying that this case is regularly appearing in the cause list. Please come, please come, please come. It happened for 1 day, 2 day, 3 day, 4 day, 5 day over WhatsApp. And thereafter, mails were also sent. But because the weather was not good, And then they will say that there is violation of natural justice. Look at the conduct and immediate upon my lordship, whatever my lordship has said. Now the weather is good, they will go before the report.
Yes. Accommodation has been sought for by the learned advocate representing the appellant on the ground of her senior. As last chance, the matter stands adjourned for this week. Tuesday, it will be taken up.
Lordship, excuse me, coming back on Wednesday.
All right, Wednesday. Put the date.
My lord, I'm for the appellant, my lord. My lord, before that, my lord, the can one is there for the, my lord, application for condemnation of delay. Delay is of 53 days, including the statutory period. Therefore, the actual delay is of 30 days, my lord. The actual delay is 23 days, lordship. My lord, I have explained in paragraph number 5.
53 days.
The SR report says that it is on time. When was the order passed? 21st of April 26. Certified copy application made?
Certified copy, my lord, applied on 22nd of May 2026. My lord, I have, no, my lord, because of not getting the certified copy, I took leave from the honorable court to file the appeal, my lord, memo without the certified copy, and that was granted. Thereafter, this appeal has been filed, lordship.
Yeah, the SR says there is no delay.
Lodge.
It's all right.
Lodge. My lord, the matter in a very nutshell, my lord, the appellant, my lord, appeared into West Bengal State School Service Commission entrance examination, and his name was recommended. That is page
Who is
35.
appearing for the commission?
My lord, service, my lord, is affected, my lord. Sorry, all affected, lord.
All right. Who usually
My lord, the
appears
school
over
service commission is not the answering party, my lord.
Not the answering
No, no.
party.
My lord, only the recommendation of the school service
And the
commission.
board, the West Bengal Board of Secondary Education is also there.
No, no, my lord. This is, my lord, the request on the part of the appellant for transfer him in a, my lord, in such a school where, my lord, his
That means
subject.
the DI will look
Yes,
into it.
yes. My lord, the state is, my lord, the answering.
Secondary.
Yes, your lord. My lord, the name has been, my lord, recommended by the School Service Commission, page 35. Against the, for the school of, namely Shilbari Hat High School for the post of assistant teacher in computer application HS.
Why you have agreed with this order?
Yes, I am coming, lordship. Because the school, my lord, that school does not have any sanctioned post of computer application.
Where is your application seeking transfer?
My lord, initially, my lord, I was, my lord, the appellant was transferred to Shilbari High School, where, my lord, the post was there, sanctioned post. Subsequently, my lord, he was transferred to Churabhangra Bhelbela High School, that is page 40. Page 40.
Yes.
Page 40. My lord, here, lordship, there is no sanctioned post of computer application. So, my lord, the petitioner made representation, that is page 41. And in the representation, he also gathered that a school at Jalpaiguri, which was a vacant, there is a vacant post of the computer application, sanctioned vacant post. So he made a representation to the, my lord, the Commissioner of School Education, that is page 41. My lord, thereafter, lordship, the representation was not taken care of. So, my lord, page 42, he filed a writ application. Page 43, lordship, kindly comes the relevant part. The second paragraph of page 43, in view of above, the respondent 2, upon issuing the prior hearing notice of at least 7 days, to the petitioner and after granting him an opportunity of hearing is directed to dispose the said representation dated such and such by passing a reasoned order in accordance with law. While conducting the hearing, the respondent number 2 shall take assistance of the jurisdictional DI to ascertain the vacancy, if any, for computer application subject in district where the petitioner is working or in the adjacent districts where the petitioner can be accommodated for the relevant subject. This is the order. Pursuant to this order, my lord, the reasoned order passed, that is starting from page 45. Your lordship kindly comes to page 46 is the relevant part. And the middle part, my lordship, I am reading this. Upon getting lordship has got it. Upon getting recommendation from West Bengal Central School Service Commission certain size, the petitioner was transferred, the first one, Shilbari High School, to Churabhandar Bhelbela High School, Jalpaiguri, and joined that school in a forenoon such and such. He is joining such and approved. Of late, it is observed that there was no sanction post in computer application in HS section in Churabhandar Bhelbela High School, and he was subsequently placed by the school authority in a normal section in science and mathematics group. Being dissatisfied on this action, the petitioner filed the instant writ before the Honorable Court praying for transfer in a school where there is a vacancy in a computer application subject. It is a fact that there was no sanction post in computer application in HS section in Churabhandar Bhelbela High School since joining of the petitioner. The permission for introduction of computer applications is obtained, but my lord, that has not been there. Lordship, page 47, lordship kindly comes. Leaving first paragraph, second paragraph, the petitioner claimed that there is a
Your application for transfer to the Rangali Bajar Mohana.
Yes, Rangoli Bajar has been given. But unfortunately, that Rangoli Bajar High School also, there is no sanction post for computer application.
Tell me, what were you doing from 2014 till 2025 in the school where there is no sanction post? You taught something else?
No, my lord. My lord,
There is no
lordship,
sanction post.
2024, the earlier school, I was, my lord, served as a teacher of a pure science.
Right. You say you are a computer teacher.
Yeah,
And
computer
for 10
application.
years, you taught some other subject.
Yes, lordship.
What
No,
did
my
you
lord.
teach
10
in the
years,
schools
lordship
and
kindly
what
comes to my
students learned, I don't
representations.
know.
Lordship kindly comes to my representations.
All right, we followed it. Is there a computer course sanctioned in
No,
Rangoli
ma'am.
Bazaar?
No, ma'am. Two things. One is she is currently with Churabhandar and she wants to go to Dhupguri. And she has been transferred to Rangali Bajna.
Yes.
She is of the opinion that Dhupguri has a sanctioned post. But Dhupguri does not have a
My
sanctioned post.
Where,
She is-
find out a place where there is a sanctioned
In
post.
Jalpaiguri district, there is no such post.
No such post.
No.
What will
In
happen?
her,
to
she is
candidate?
relying upon an RTI reply.
How
All
you
right.
can appoint it?
That RTI reply,
Is incorrect.
we are not able to trace as to how that RTI reply has been obtained.
All right, we get it. Then what is to be done with this candidate? This teacher, what?
She has to go out of district, and that will not happen because they will not agree to it.
No, lordship. I have not been given any such
Show me a
proposal.
place where you can be
My
accommodated.
lord, lordship kindly comes to page 53A. There is another school, that is Jalpaiguri High School. This is the of computer application. This is the document of the West Bengal School Service Commission. Page 53A,
The
lordship.
DI says that there is no school with computer.
My lord, this is the document of the West Bengal School Service Commission. Lordship kindly comes to page 53A.
No, he's taken current information.
My lord, let them file a report that there is no school, my lord, of the computer applications here.
The report is already there.
My lord,
If I can have my lordship for a moment on my lord's.
because my
Paragraph
lord,
6,
there is a reply to the RTI of the headmaster of the Dhupguri school, where my
That
lord,
reply will not do. You have to have it on records. The DI will be the best person, the state authority.
my lord,
will be
let
the
me
best
see,
person.
let me go through the report, my lord, and let me allow to file the, my lord, exception to that report, lordship.
What exception? These are matters of record. What will you file an exception?
No,
to this?
because lordship,
How can
the
you
West
controvert?
Bengal School Service Commission itself in its documents is saying that there is a vacancy of computer applications. And secondly,
Commission, first I inquired who is for the commission. You said commission is not the answering party. Now you rely upon the commission statement.
My lord,
Then
because the
require
question,
the commission's
question has
appearance.
arisen, my lord, that is why, my lord, I am relying the document of the commission,
The
lord.
commission is required. How
And my,
can the commission say? Here, see, Dhupguri informed in an RTA reply that the post of is lying vacant in certain post. However, the school authority could not produce any post sanctioning memo. As a result, could not ascertain the existence of vacancy in honorable litigation. Our prayer for issuance of the duplicate circular.
Even the duplicate copy of the post sanction memo was not with them.
Who sanctioned the post? Where is the post?
How is the point?
It was by mistake. It was absolutely by mistake, and the candidate is there for since 2014. We are in 2026, teaching something else.
no,
and
my
God
lord,
knows what the
2024,
student is doing.
my lord, 2024.
2014, your transfer order.
No, lordship, that page 40, lordship, valid comes, that is 2024, lordship.
What 2020? Page 40.
No.
2014, I have checked up.
2014.
Ah,
2014.
from
2014.
2026.
My lord, that is why, my lord, the
What
representation,
if the students-
representation made, lordship, kindly see.
Just imagine. the Student of computer, what is happened to the students? That is the reason this is the standard of the government schools. Now, what is to be done if there is no
That is the reason I wanted for a written instructions to be there before.
divisional instruction is there?
Yes.
The DI is
Now,
there.
I am of the opinion she has to go outside the district because this will not be done by the DI. This has to be done from an upper level as to what sanction post is there in respect of computer education, whatever is
This-
there. he
The
has to go there.
commissioner of, the moment it goes
Yes.
out of the district,
Yes.
it has to be done by the
By the
commissioner
commissioner has
of
to
school
do it, the
education.
commissioner will ascertain whether there is sanction post for computer application or not. If there is one, he has to go there. That will
Where
be
is
the
your
appropriate
appointment
service.
letter?
My lord, the lordship kindly comes to page 35. The first one, lordship,
No, you were appointed in which post?
computer application,
Computer
lordship,
application.
page 35, lordship.
See, the school service commission appoints you in computer in 2008, right? And then you get transferred,
Yes.
and this is in Malda. Right now you are in Jalpaiguri,
No, right now, my lord, I am
Surabanga.
Jalpaiguri, Surabanga.
in Jalpaiguri district, right? Now this is in Malda. So initially, you were recommended to a school.
That is Shilbari Hart High School.
Appointment letter, Shivari Hut High School in 2008.
In 2008, this Silbari Hat Alipurduar itself was part of Jalpaiguri.
Yes, that is the reason. Now, please come. The petitioner was appointed in the post of assistant teacher in HS section in computer application in the year 2008. So he joined Shilbari Hut High School within bracket HS page 37. Check this spelling. Thereafter, he was transferred. He was recommended for transfer to Chudavandar,
Correspondent number 6.
page 40. Spelling. Transfer recommended to. Stuff. Specific case made out by the petitioner is that there is no post sanctioned for computer teacher in the Chudavandar High School. Puro namta deben. The petitioner applied for transfer to some other school where there is vacancy in the post of computer application. The prayer of the petitioner not being considered, the petitioner approached the writ court by filing writ petition WPA 90 of 2025, which stood disposed of on 24th of January 2025, directing the District Inspector of Schools to issue a prior notice of hearing to the petitioner and to dispose of his representation. Stuff. Who was the respondent number 2?
My lord, in the writ, lordship,
In the earlier writ,
lordship, the Directorate of School Education. The who passed the recent order, lordship. Next page, page 45. Commissioner of School Education, lordship. Commissioner of School Education.
Commissioner of School Education. Do know যেখানে বললেন না DI, ওটা হবে Commissioner of School. The court directed the commissioner to take the assistance of the jurisdictional DI to ascertain the vacancy for computer application subject in the district where the petitioner is working or in the adjacent districts where the petitioner can be accommodated. The Commissioner of School Education heard the petitioner and directed not directed and recommended appointment of the petitioner in Rangali Bajna Mohan Singh High School within bracket HS. Page 48. Stuff. Paragraph. It has thereafter transpired that the said Rangali Bajna Mohan Singh High School also does not have any sanctioned post of computer application in higher secondary section. Stuff. The petitioner filed a further writ petition disclosing his proposal and disclosing his request, application requesting for transfer in Jalpaiguri High School. The said writ petition being WPA 496/2026 to disposed of on 21st April 2026. Wherein the learned single judge recorded that there are 2 posts available at Rangali Bajna Mohan High School and the petitioner is eligible to join the same. Submission of the appellant is that as there is no vacant post, no sanctioned vacant post in Rangali Bajna Mohan Singh High School, post in the subject computer application, the petitioner cannot join the same. Stop. Prayer has been made to direct the authority to transfer the petitioner in such a school where there is a sanctioned vacant post in the subject computer application. The learned AAAG relies upon the information forwarded by the District Inspector of Schools, Secondary Education, Jalpaiguri, signed on 30th June 2026. Stop. It appears therefrom that the post sanctioning memo of the Jalpaiguri High School, where the petitioner claims that there is vacancy, is not available. Stop. The Which portion there is
The
mentioned?
duplicate
there is-
copy, the last line, Lord, paragraph 6,
Paragraphs.
within inverted commas.
Uh,
This office is not in a position to issue a duplicate copy of the said post sanctioning memo
that is
as no,
Dhupguri. That
as
is
no office
Dhupguri.
copy.
That is Dhupguri.
Dhupguri.
No, but then other schools also there is no post. Where from are you getting?
Oh, that is in page 47 of the writ petition. The order that was previously passed, it says there is no vacancy for the relevant subject in the district of Jalpaiguri.
Page 40.
47 of the writ petition.
My lord, kindly consider page 53A once.
No sanction in permission for introduction.
The petitioner claimed that there is a required vacancy in Dhupguri High School, but actually there is no vacancy for the relevant subject in the district of Jalpaiguri.
This is possibly is a submission of the petitioner.
No, my lord. So searching was made in adjacent Alipur district.
Hmm.
This is what the authority is saying. The district inspector of school Alipurdwar by member such and such has confirmed the vacancy of computer application at Rangali Bajna.
Right, but thereafter it transpires that.
That even Rangali
Bajna
Bajna does not have
then
something.
find out
So
one.
now what will happen is that he has to, in adjacent district, he has to.
Yes, that is the order also. Justice Anita Roy's order says.
Yes.
Either in Jalpaiguri or in
Or
the
adjacent district. So it's- now the adjacent district search has to be made.
My lord, there is a list by the commission, my lord, page
Yes.
53A. My lord, that
53A.
in Jalpaiguri lordship for computer application, there are 1, 2, 3, 4, 5 schools are there. High secondary lordship.
53A.
53A lordship. 53 is the list and 53 is the type copy.
Actually, according to the DI, there is no vacancy in the sanctioned post of computer application throughout the district of Jalpaiguri. The aforesaid contention is denied by the learned advocate representing the appellant. Reliance has been placed on a list annexed to the stay application, allegedly appearing in the website of the West Bengal School Service Commission, containing the names of these schools in the district of Jalpaiguri, where there is vacancy in the subject computer application within bracket PG.
Altogether 6.
Then next is Malda and Murshidabad. 3 and 3, 6. And this one. None appears on behalf of the West Bengal School Service Commission and the West Bengal Board of Higher Secondary Education. Let notice be served upon the non-appearing respondents. The learned counsel representing the commission and the board shall produce the list of schools where there is sanctioned vacant post in the subject of computer application in the district of Jalpaiguri and the adjacent districts. Lists this matter in the next circuit.
Grateful, your lord.
The report is written with the records.
My lord, urgency, my lord, is this, my lord, the counseling for the said post, my lord, has been started by the commission, my lord. The counseling, my lord, for the said post, my lord, has been initiated, my lord. So I am, my lord, in a
Counseling where?
my lord, for the said post, my lord, the computer application.
Counseling must be for the fresh appointees.
Fresh appointment. My lord, now vacancy can be, my lord, filled up, my lord. Maybe there is a chance of filling up the vacancies, my lord, that is why.
Is anybody making submission?
And Orkoditya Sengupta, my lord, he is appearing with me, my lord.
Mr. Sengupta, are you making some submission?
My lord, he is saying about page 53A.
Your voice is cracking, the court cannot hear you, somebody is here, we have heard and passed order. Read the service system.
Grateful, your lordship.
Deep your bell.
My lord, I am for the appellant, my lord. On earlier occasion, the matter was dismissed for default, my lord. Thereafter, my lord, the restoration application has been filed within due time, my lord. And on basis of earlier direction, my lord, I have duly served, my lord, all the respondents, my lord. And my lord, this is my affidavit of service, my lord. My lord, kindly the matter may be restored in its present form.
And I beg to appear for response number 1 to 3, my lord.
There he is appearing.
Yes.
You received copy?
No, I've received the copy of the restoration only.
Restoration only? All right.
I do not come in the way of restoring it, but if you also kindly sees the explanation, no explanation at all. Why the advocate could not appear? Nothing is written.
I think he was appearing in court, another court.
That has not been written.
You have to write it. Otherwise objections are raised.
But kindly the matter may be restored.
One line is there, learned court as the
Paragraph
learned
3.
advocate was
In
in
court
court
number
number 5. Something is written. It's to dismissed. 21st of April. And 20th of May it has been filed. All right. Allow. Let a copy of the appeal be served on the learned advocate representing the respondents.
1 to 3, not all.
Acha, 1 to 3.
Stay
Who are
application,
the
have you
others?
filed? Have you filed the stay application?
Yes, my lord. Stay application has
Stay
already.
application.
1 to 5.
This is can 2.
1 to 3. There are other private parties also.
Yes, my lord. I have served all the respondents. However, my learned senior is appearing
Let
only for.
notice be served upon the non-appearing respondents.
Yes.
Further notice. List in the next circuit.
Admit হয়েছে? Admit হয়েছে?
It has to be admitted first.
It has been admitted?
No.
No, it has not yet been admitted.
Admit করবো। Grounds.
Substantial question of law has to be formulated.
Claim করতে হবে, এখানে তো সার্ভিস করতে বলাই ছিল। You serve, come back in the next circuit.
My lord. Good. Yes. Item number 11.
Grateful.
If you direct Malan, concerned respondent Malan, I have already served Malan. But track report is Malan, that is up to Kuch Bihar. You should kindly see that track report.
Restoration.
Yes. The restoration has already made Malan, I think.
It has been restored.
On the last occasion?
Yes, it has been restored.
Yes, Malan.
Sorry, track report is not ready.
Track report only Kuch Bihar, not received, delivered.
Then what can be done? We keep it next week or what?
You
Or
should
next
kindly-
circuit?
Next circuit, Malan. You should kindly liberty to give service to the concerned advocate, Malan. Lower court advocate. This is appeal, Malan.
There is no proof of service. There is no proof of service upon the respondents.
কিছু ডিফেক্টস আছে, ডিফেক্টটা তো মেমো কপি পাওয়ার একটা কিছু দিয়ে নিয়ে যায়।
Section 5 application is there.
কপি শুধু বলে
95
দিয়েছে,
days.
অ্যাবসেন্ট তো দিতে হবে না। ডিগ্রি এগেইনস্টে আছে, অর্ডার এগেইনস্টে আছে।
Can't.
Putting this below has been allowed. There is only
Memo
the memo
copy
of
was
opinion is
properly
properly
not classified.
classified.
That should be
He
classified.
can take steps for covering the defect. Was there any order for curing the defects?
No, my lord, defect only, my lord. Section 5 not
No,
back.
no, there
No,
are
no,
other.
apart from that, there are defects. Please check up.
I will.
Respondent, stop. The appeal is defective. Stop. Learned advocate representing the appellant is directed to cure the defects. Stop. Let further service be effected upon the respondents. List in the next circuit. Affidavit of service is taken on record. You can try out
Yes.
either to the party or to the advocate, whoever. Something should be there.
I will.
Lordship, in item number 12 and 13, I am for the appellant. Service already infected earlier panel. It is required for the appeal.
You didn't serve the new councils?
No, it's
New-
the first thing. I'm just told 12 and 13.
Acha.
The respondent.
Private
Change
respondents
in
are-
the- Due to change in the panel of learned advocates representing the state, Amanan is appearing on behalf of the respondents. Stop. Learned advocate representing the appellant is directed to effect fresh service upon the respondents. Stop. List in the next circuit.
The private respondents already appear.
Private
Yes, yes.
respondents appear.
Generally, your lordship, Mr.
Matter in-
Uday Shankar Chattopadhyay, senior advocate, he appears on this matter. Suddenly, he might have engaged in some personal issues in Calcutta, your lordship. He couldn't able to join.
Can't help.
Yes. Practically, this matter relating to land acquisitions, quantum of the land and valuation of the quantum. So private respondent mainly answerable.
Will we keep it next week?
Lordship.
Will we keep it next week
Next
or
circuit,
next
it's
circuit?
better, next circuit, your lordship.
Next circuit.
Actually, is-
Let's say,
Honorable.
if the matter.
No, he
comes,
says
then
next
week
Sunday.
we
Yes,
do
yes.
this matter.
I have been instructed like that. He will appear personally. That's the point.
Whatever.
12 and 13, same.
All right, same order.
12 and 13.
Fifteen,
And for the respondent number 2 and 5 stated there.
2 and 5.
Yes, the accountant general.
Item 15, my lord, is that case wherein that pensioner is waiting for his pension from 2015 onwards, SAT matter. In this case, my lord, my submission last occasion was that this will be disposed of, taking into view the Rafiq Masih judgment.
Yes,
But the
but then the petitioner is not,
So even if we want to help them, they are not here.
not willing to take it.
Not willing to help. What can be done? I will explain what happened in this case. He
What
retired in
is the name? It's
2015.
Arnab Shah. Where is he?
He retired in 2015. Thereafter, he applied for commutation of 1/3 of his pension.
Hmm.
The commutation was done, but the allegation from on behalf of the respondent authorities is the employer is that during that commutation, the component that was taken into account has resulted in an excess payment of 3 lakh something. Rafiq Masih judgment, there is an exception to that. There are 4 exceptions. He falls within the exception 2. Because from a retired employee, that cannot be done. So I was willing to help him. Only because my lord said that my lord will not make any observation regarding non-functioning of the SAT and everything.
Mr. Shah is inside. He's happening already.
Yeah, I'm for the petitioner, lordship. So over the issue, I'm giving a short brief of the entire issue, lordship. Over the issue of an excess payment due to
wrong revision of the pro rata pension of the petitioner, the amount of the sum amount was started to deduct from the pensionary benefit from the pensionary account of the petitioner in the year of 2010. That was complained of by the
Where is the
petitioner.
document to show deduction? Where is the document to show deduction? Which
Page
page?
52, 5 to 50.
Please take down.
But due to clerical mistake,
The petitioner is a retired employee. He's a teacher or what?
No, my lord, food
no,
supply.
he's an inspector with a
Food supply.
Um,
Government of West Bengal, then he has been absorbed in Food Corporation of India.
Food and Supplies Department. So he is aggrieved by the deduction of certain amount of pay from his pro rata pension. Stop. The petitioner retired from service when?
he retired from service in the year.
30th
He
of
superannuated on
30th of June 1984.
3rd of June 1984.
30th, it cannot be third, it will be 30th.
Oh, 30th of June 1984.
30th of June 1984.
The PPO was issued in 2005. 1905,
And the
2005.
pension payment order was issued in its favor in the year 2005. Stop. The deduction
Was on account of
started-
commutation of pension.
started on and from 1st of September 2014. Stop. Paragraph. The petitioner, aggrieved by the said deduction, approached the West Bengal Administrative Tribunal by filing OA 267 of 2015. Stop.
No, Lordship.
He said
OA
application.
number 272.
Who is 27?
272 2015.
267 is somebody else's matter.
Yes, there were many.
Yes.
Oh, there are many.
Many.
Acha, 272 of. Yes, he said, original application is pending till date due to non-functioning of the administrative tribunal.
But it is also part of record that in the last 5 occasions, none appeared for the appeal before the tribunal.
Acha. The instant writ petition has been filed. Praying for a direction. See prayer B, take steps for filling up the vacant posts.
Yes, that is there. But then the
Internally are praying for early disposal
Yes.
of the, praying for, internally are praying for a direction upon the tribunal for early disposal of the original application. Stop paragraph. It has been brought to the notice of the court that the West Bengal Administrative Tribunal, State Administrative Tribunal is not functioning due to want of members. Stop. Remanding the matter to the tribunal for early disposal will not serve the purpose of the petitioner. The petitioner is a senior citizen, is an octogenarian. Stuff. Delay in disposal of his application will certainly result in miscarriage of justice. Stuff. Since the issue as to whether any sum can be deducted from the pension, from the terminal dues of a retired employee is no longer res integra, and the same has been categorically decided by the Honorable Supreme Court in the matter of State of Punjab and others versus Rafiq Masi within bracket whitewasher and others reported in 2015 4 SCC 344 that recovery from retired employees is impermissible. Accordingly, the court is minded to entertain the instant writ petition and dispose of the same on merits. Learned Triple AG has brought to the notice of the court that the petitioner himself did not take any steps before the tribunal on several occasions. Next. Upon hearing the parties and on perusal of the documents annexed to the writ petition, it appears that the petitioner retired long back in the year 1984. The commutation of pension was calculated where certain overpayment, excess payment was detected. The authority intended to recover the excess payment made to the petitioner. Such action on the part of the authority would be clearly impermissible in view of the dictum of the Honorable Supreme Court in the matter of Rafiq Masi. Next, in view of the above, the instant writ petition stands disposed of by directing the respondents to refund any amount that has been deducted from the terminal dues of the petitioner at the earliest, but positively within a period of 8 weeks from the date of communication of this
No
order.
amount was deducted. Actually, he completed his 15 years, so thereafter the full pension has to be restored. At that point of time, it came into the notice that 3,80,488.
Is he getting, are you getting part pension or
No,
something?
no. Deduction in tangible form is being made. They are writing in a disclosure statement under RTI that there is no such deduction is being made, but from the account itself.
It's ambiguous. He says deduction.
Where is you have annexed the pension paper in your petition?
Anything to show the deduction has been
Where
made?
is the
Which
deduction?
page?
Please show.
Which page?
Comes to.
Yes.
My lord, one inspection was held by the respondent number 2 and 5, and they had made a report to the treasury that excess payment has been made. This is the part of respondent number 2 and 5 only.
Now you cannot.
Which page?
recover
Page
the-
55.
Recovery has not been made.
65.
The tables are there. 55. Also, the table is there.
65.
It actually starts from 54. The authority says that upon the bank account revealed that our pension has been. Oh, no, this is the representation. I'm sorry.
Because of such deduction, this representation was made.
Page 61, he's right.
Page 61 onward.
But the deduction.
Page 61 onward.
61 onward.
No, the overall is 0.
The
kindly
terminal
come-
dues
No.
is
The
number-
overall as per page 66 is only 1, 2, 3, 4, 5, 6, 700 rupees.
Your kindly comes to page 68, where the DNS relief, medical relief have all become 0. And the pension have reduced to a.
All right, direction has been passed to
Without-
refund.
without interest.
Exactly.
Obliged, ma'am.
Refund, my lord, if any deduction.
No, there was deduction. There was
Deduction has to be refunded.
Yes,
This is what the Supreme Court says.
Yes.
Lordship, I also rely upon two other judgment also, Lordship. It can be taken on record, Lordship. Other two judgment of the Honorable.
What are the
Supreme Court.
They
judgments?
wanted it next circuit. He said that.
Jagdish Prasad Singh.
Oh,
Jagdish Prasad Singh and Sushikala Devi. Lordship, kindly peruse the judgment. Kindly hand. I would
Sir,
like to.
use-
Lordship, relying upon the same judgment.
give the
Yes,
citations. Citations were in-
citation.
Learned advocate for the petitioner relies upon such and such.
Lordship, deduction to be, Lordship, deduction amount to be refunded within a stipulated period of time. Otherwise, the Lordship.
8 weeks, 8 weeks
Yes, grateful, grateful.
from the date of communication.
Grateful, Lordship, grateful. High level. Lordship.
And you have not sought for any interest? Have you?
Yes. Sorry, no, sorry. It should be. Along with interest.
What should be fair for interest?
Lordship, otherwise, then the further litigation will be raised, Lordship.
Have you prayed?
No. The prayer.
No. I have prayed an alternate. Lordship, kindly appreciate. I have prayed an alternative prayer also in my prayer. That if the tribunal, what the original prayer was made out in the tribunal, the same should be allowed by this honorable court as well. I have prayed in the.
Where is the prayer before the tribunal for interest? Which page?
Page, kindly see.
Check up whether there is prayer for interest or not.
Page 21 onward. 21 onward, page 35.
No. There is no.
Sorry, Lordship.
He hasn't paid for interest. Not even before the tribunal.
No prayer before the tribunal for interest. So sorry, no interest order can be passed.
I don't know, 16.
16 and 18 lordship are happening for the applicant lordship. For the confused. It will not take much time.
Are the respondents there?
Yes, my lord. Clear that. This, my lord, is a very peculiar case.
The pension has not been disbursed.
I will explain why.
Petitioner has been applicant has been superannuated. No departmental processing. Lordship, I will just go through the BCIB rule and the control classification.
Very well, on the prayer of the learned advocate representing the petitioner, list the matter on 8th, Wednesday,
My lord.
16 and 18.
Same matter.
Lordship, item number 17, I am for the appellate.
Union's petition.
Lordship, post office,
And
postal department.
where is the respondent? Sir?
Copy served and filed. Review of service. The writ petitioner filed the contempt application. Lordship, here in this case, writ petitioner got the job in the back door, from the back door, when he is a minor. Lordship, kindly put the engagement notice, your Lordship, page.
No, in the absence of the
18.
respondent, we will not hear.
But your Lordship, then I'll serve the copy to the learned advocate who filed the contempt. But in the meantime, your Lordship, grant the stay. I have the very good case, your Lordship.
Wait, who is the
With the
learned
judge.
advocate?
Lordship will start.
You will search 12th of June 26.
Item delivered to the address, your
the
Lordship.
address, Firoz Alam. Show the impugned order.
Lordship, so the impugned order is the last. Page 122, the impugned order. Before the impugned order, your Lordship, kindly consider page P1, page 18, your Lordship, the engagement notice.
Yes.
The Lordship, the eligibility criteria, age limit is 18 years, your Lordship. Now, your Lordship, subsequently, on.
Can you serve Mr. Photik Chandra Das? He appeared for the applicant in the original application.
I'll serve.
Why don't you serve the learned counsel? He'll appear immediately. Take information of the phone number from somebody,
Lordship.
Mr. Photik Chandra Das, and give a notice to him.
Lordship.
All right. When is the next date?
Lordship, 12 July.
12th of July. So we are here till the 10th. Right? How can it be 12th of July? 12th is a Sunday.
12 and 13. This month, here.
13. So next week we have time. You
Lord-
intimate Mr. Photik Chandra Das.
Lordship, kindly upgrade this matter. Otherwise, your
It
Lordship.
is there in the list, top C. It's only 12:25. The matter has been taken up.
Lordship, then I come back 7 or 8, your Lordship, within 8, I will serve the copy. Sir,
Collect the phone
6,
number.
7.
There are
Lordship,
many
I'll try.
friends, you must be having friends in
Lordship,
the
Lordship,
principal
I'll try.
bench. Take his phone number and please serve a copy,
Lordship,
at least a notice,
Lordship.
right? So he will appear. None appears on behalf of the respondent despite service. Stop, affidavit of service filed in court is taken on record. Stop. Let a notice be served upon Mr. Putik Chandra Das, learned advocate, who represented the respondent before the tribunal. List on
Lordship, 8 on the top, your Lordship.
absolutely on the top.
Lordship,
8.
Lordship, 8 on the top.
In case it is not taken up, please mention, we'll take it up.
Lordship, get it.
ছিল তো করলো এবারে নিজের হয়ে গেছে।
19 item number.
Your Lord, Mr. Zakir Hussain was supposed to appear online, but then since he's not there,
I have for the state ballot.
for the account, in the absence of Mr. Zakir Hussain, it will not be prested, not today. Your Lord. He was supposed to appear virtually, but then
He's not there?
he's not there. Your Lord.
Ready?
I have a point on maintainability.
Alright. Not today.
Good.
Adjourn for the day on the prayer of the learned advocate representing the petitioner.
Grateful, Your Lordship. Appearance.
Not today, not today.
হ্যাঁ অর্ডার হবে অর্ডার হবে
Item number 20.
This matter will be kept on for further hearing on the next Wednesday.
Who's for the respondent?
States are represented.
Miss Rashika Agarwal. Accommodation has been sought for on behalf of the learned advocate representing the petitioner. Petition appellant. Stop. None appears on behalf of the respondents. Stop. List the matter on Wednesday.
If possible, the next circuit.
What do you mean to say if possible?
Lordship, as they are not appearing, I have to.
It is your appeal. It is not their matter.
Then Wednesday. Lordship.
Wednesday.
Which one item number?
Yeah. Has paper books been filed? No. Find a cargo null for.
adjournment.
শুধু অ্যাডজার্নমেন্টই মামলাটা কিছুতেই ডিসমিস করে দিলেই এখন একটা রেস্টোরেশন নিয়েছে।
বাড়ি সাহেব আছেন বাড়ি কি হবে? ডিসমিস করলে কি হবে?
হ্যাঁ?
ডিসমিস করলে কি হবে? ওদের লাভ
None for the appellant. None for either of the parties. Appellant করবে না, none appears on behalf of either of the parties. ঠিক আছে? List on it. Stop. It is made as list on it under the heading for dismissal. The heading পর্যন্ত উপরে for dismissal.
ফার্স্ট লাগাতে ডিসমিস রেস্টোর করলে কস্ট আমাদের দেশে এখানে জলপাইগুড়ি সার্ভিস আছে তো
আছে?
লিগাল সার্ভিস আছে
হ্যাঁ।
2000 দিলে
কিছু টাকা আসবে।
রেগুলার বসছি
I don't know, 22.
Yes?
Your Lordship, I'm led by Senior Advocate Mr. Amlesh Rai. In his absence, if Your Lordship pleases to list the matter next week, he'll appear. He'll come physically.
What about the respondent? Satyaki Basu?
I am for the appellants.
You are Satyaki Basu?
I am for Mr. Amlesh Rai.
That I understand. Where is Mr. Satyaki Basu who is appearing for the respondent?
Yes, ma'am. Your Lordship.
My lord, kind leave to mention one matter, your lordship. It's a urgent principal bench matter, your lordship. My lord, the petitioner is seriously ill, your lordship, and prayed for an electricity reconnection order, your lordship. The lord may kindly hear it from the circuit bench itself, your lordship.
Correction.
Lord, may I kindly mention, Lord, may I kindly mention one urgent matter of principal bench, your lordship. Petitioner is seriously ill, your lordship. Kindly take up this matter from the itself, your lordship. Am I audible, your lordship?
Lordship, praying for next week, Thursday, Lordship.
It was adjourned on the last occasion, so no
Lordship,
adjournment will be granted.
Lordship, the advocate on record, some close relative has expired, Lordship. Therefore, I'm praying for on Thursday, Lordship. Kindly, Lordship, on Thursday.
On the prayer Thursday.
Grateful.
Am I audible, your lordship? My lord may kindly take up this matter from the circuit bench itself, your lordship. The petitioner became seriously ill, your lordship. An urgent need of electricity connection is required, your lordship.
Three, I'm praying for not place this application, my lord.
Not press. Lordship, I am on the purpose. Record your appearance.
Am I audible, your lordship?
Item number 4. Not press.
No, my lord. Item number 4, praying for Thursday, my lord.
So praying for Thursday.
Yes, my
Thursday.
lord. Thursday.
Item number 5.
I want to not place this application, my lord.
Not press.
Yes, my lord.
Item number 6.
Plus 6, praying for Thursday, my lord.
Thursday.
Yes, my lord.
7.
Item number 7, my lord, praying for short Passover. Mr. Ganguly is appearing on court number 10. Grateful, my lord.
8.
For the petition. This is a case under section 20 B2C 25 and 29 of the NDPS Act. The allegation is that acting upon a source information, police apprehended 2 vehicles. Upon seeing the police, one vehicle has been run away from the spot and subsequently dashed in the anti-crash pillar. And from the vehicle, all the accused person has been fled away. And from that, and another vehicle, that is the vehicle number 7289. From them, 3 accused person have been arrested. And subsequently, from that vehicle, 22 kg gaja has been recovered. And from the vehicle, which from the all the accused person have been fled away, from that vehicle 45 kg gaja has been recovered. The police, what the police did, police put the blame of that that vehicle and upon me, my lord. So from 3 accused person, police showing that 67 kg gaja has been recovered. But the actual case is that from the present 3 petitioner, here is 2 petitioner. From the 3 petitioner, 22 kg, only 22 kg gaja has been recovered, my lord. No, so far my
From
instruction,
2
no.
of the petitioners.
From 3 of the petitioner. Before your lordship, 2 petitioner.
2 petitioners
Yes.
are here. From them.
From 3 accused person and from the vehicle, 22 kg gaja has been recovered. If your lordship kindly see the seizure list, that is, my lord, page 38. Page 39 is the operating portion, my lord. The articles noted in serial number 1 and 2 were found from the secret chamber of one silky silver Suzuki Eco motor car bearing registration number 7289. And my lord, from the first page 1 and 2, that is 22.21 kg. But my lord, what police did, my lord, police put the blame of that vehicle upon us, my lord. From our vehicle, only 22 kg gaja has been recovered.
You were in which vehicle?
I was in vehicle number 7289.
7289. Where is it mentioned?
My lord, kindly comes to the FIR.
Yes.
Page 35.
Total NDBS allowance is 67.560.
It is a total
So, yes, it
from
was
two
in
vehicles.
two vehicles.
Yes, my
You
lord.
were there in one of them.
One of them, my lord. Page 35, my lord. Page 35, first paragraph. 1, 2, 3, 4, 5.
7289.
My lord. Paragraph 35, 7 to 8.
Both were running together.
Both were running together, my lord.
Yes.
That is the allegation. But from our vehicle and from our possession, my lord, only 22 kg gaja has been recovered. But my lord, police put the blame upon me.
Anyway, so even 22 kg is beyond the permissible limit.
My lord, charge sheet has been
20.
submitted. I was in custody about more than 293 days, my lord. My lord, at any condition, my bail may be granted. So far, my instruction, my lord, separate sheet of ground up arrest are also not provided to us. Provided.
May I submit letter? My lord, two vehicles, all are my lord involved. They, what they did, they separated the contraband articles into the two vehicles. One vehicle, my lord, crashed and the passengers, they fled away. The other vehicles, my lord, three persons were, my lord, apprehended. And my lord, from the secret chamber of that vehicle, my lord, the contraband articles have been recovered. My lord, all formalities like, my lord, the presence of the executive magistrate, the presence of the independent witnesses, everything have been done.
Complied.
Videography done, complied, my lord, ground of arrest, everything done, lordship. So what my learned friend is saying, it is a matter of trial.
Not only that, all the other accused, their prayer for bail stood rejected.
Rejected.
All.
My lord,
Even
No,
from
sorry.
the High Court, my lord.
my lord, in our vehicle, another accused person was Farman Sheikh, whose bail was rejected, my lord. My lord, kindly consider at
The
any condition.
Petitioners are in custody for
293 days.
93 days. Stop. Commercial quantity of ganja-like substance was recovered from the vehicle in which the petitioners were traveling. Stop. Paragraph submission of the petitioners is that they were traveling in vehicle number WB51 caps E hyphen 7289, from which only 22.21
kg, my lord.
kg of ganja-like substance was recovered. Stop. The petitioners were not involved with the offense, but they have been falsely implicated. Stop. Paragraph. It has also been submitted that the formalities at the time of arrest were not complied with. Stop. The aforesaid contention of the petitioners is denied by the learned advocate representing the state. Stop. The prayer for bail is opposed. Stop. It has been submitted that two vehicles were traveling together along with the contraband articles. Stop. The petitioners were traveling in one of the vehicles. Stop. All the formalities required at the time of arrest were duly complied. Stop. Videography was done. Stop. The prayer for bail for the co-accused were rejected. Stop. Paragraph. Upon hearing the submissions made on behalf of the parties and on perusal of the documents on record, it appears that admittedly commercial quantity of contraband articles were recovered from the vehicle in which the petitioners were traveling. Stop. The petitioners are unable to overcome the rigors of section 37 of the NDPS Act. Prayer for bail stands rejected.
Grateful, your lordship.
I don't know, nine.
Your Lordship, I am praying for Thursday.
State is there? All right. None for the petitioner. List on
Your lordship,
8th.
your lordship, am I audible?
Lordship, I'm praying for Thursday. Lordship kindly keeps the matter on Thursday. It's appearing for the first time.
You are for the state?
Yes, ma'am.
Why Thursday?
Lordship, actually, we are not prepared with the matter. It appeared
You
today.
filed it without preparation. How can that be?
No, Lordship, it was supposed to appear tomorrow, but it had appeared today. We were not prepared.
Supposed to appear tomorrow.
Tentative date was given for tomorrow, Lordship.
Did you check up?
Lordship, we have instructed our clerk to, we have given the date, tentative date to appear on Tuesday, Lordship.
Which Tuesday?
Lordship, next week, Tuesday.
Next week Tuesday?
Yes, Your
The
Lordship.
presentation is formed by a learned advocate.
Lordship, that application was filled by our clerk, Lordship. There was a
Never
miscommunication.
say this. Somebody else fills the application and you sign it without looking at it, or you sign a blank page, is not a submission which can be taken from a learned advocate. I have the record in front of me.
I
do not
apologize,
see-
Lordship.
I do not see what you are submitting is tallying with what is there in front of me. Proceed with the matter, or else it will be dismissed.
Lordship, then I would like to not press the application. A fair submission, Lordship. Kindly keeps it on Thursday. We'll do the matter.
So whatever you submitted previously was all playing with the court.
No, Lordship.
Then what? After all this, you say you do not want to press. What does this mean? You are trying to test waters?
No, Lordship.
Madam, you are at a very junior stage. Never try to do this.
I apologize, Lordship.
Clients will come and go, but you will be a part of the institution. And the judge is going to keep you in mind throughout. It is a very bad precedent. Do not do anything like this. This is not the first and the only matter that you will be doing. There will be clients
Yes, Your
coming to
Lordship.
you in future. It's a very bad practice. Suppose a complaint is lodged against you before the Bar Council, what will you do? Your profession will be at stake. Never play with the court. Do you get it?
Yes, Your Lordship.
Dismiss not pressed.
Item number 11. I know wrongly listed this application. So this is the anti-well.
Right. Very well. Released for want of determination, be placed before the bench having determination. Released. দেখে নিন একটু বেলা অ্যান্টিসিপেটেডই হবে তো বলছি এনডিপিএস এর কি নম্বর পড়ছে এনডিপিএস এর নম্বর যেখানে অ্যান্টিসিপেটেডইতে কি নম্বর পড়ছে যদি অ্যান্টিসিপেটেডই হতো তাহলে কি কেস নাম্বার পড়তো এ পড়তো আচ্ছা ঠিক আছে প্লিজ কাম লিখে নিন তো দি petitioner prays for anticipatory bail. Stop. Wrongly it has been filed before this bench. Now before the filing section. Stop. Let the number be corrected and a fresh number be inserted.
Grateful, my lord.
Item number 12.
Item 12, leadership arm for the petitioner.
On parity, my lord. The other accused persons are on.
Check up.
Yes.
If it's possible.
Tuesday.
Wednesday, I keep it. Wednesday, let the CD be produced on the next date.
Section you go, not first. You go.
Paragraph 16.
16, my lord, I appear on behalf of the petitioner. Now, the primary allegation is 302.
Mr. Devabroto Rai. You.
I don't even the same page. We don't have the CD.
But then last occasion also was a CD not available. It was taken up in June, 17th of June. May also, May nobody was there. Get hold of the CD.
This option.
Wednesday.
Tuesday, Wednesday, any day.
Wednesday. Let the CD be produced on the next day. Record your presence, please. And only your presence.
I know 17. 17 will not have.
Is the CD there? Very well. Wednesday. CD be produced.
Item number?
Not 18 and 19 arise out of the same proceeding.
Miss Panchali Deb Sikdar, you? CD is not there? CD is not. Get hold of the CD. I'll post it next week. Next week. All right, Wednesday. CD be produced. Both the matters, 18 and 19.
So grateful. Oh,
For the petitioner, my lord.
Is the petitioner there?
For the petitioner.
Thursday. And for the petitioner, list on Wednesday. Okay. Item 20, are you there?
Yeah, my lord, I am for the petitioner, my lord.
I'll keep it on Wednesday because the CD is not there.
My lord, my lord. My lord, may it be on Thursday or Tuesday, my lord? Tuesday or Thursday, my lord?
Thursday.
Thursday, my lord. Grateful, my lord.
Deeply obliged, man.
I am for the de facto complaint. Because the bail application.
Let us see whether the petitioner is there or not. All parties are there without the petitioner. Sudeep Guha. Sudeep Guha.
He was present in court, but I've seen.
You've seen?
Yes.
None for the petitioner. List on 8th.
So it is present with the CD.
Next day.
I'm great.
22.
22, my lord.
All right, Wednesday.
23.
My lord, we have received the application today, my lord. Kindly fix it on.
My lord, the victim girl has filed this cancellation of bail, my lord, without considering the section, my lord. The landed court below has granted bail, my lord. My lord, is there
My lord,
one?
kindly on witness, my lord. We have just received it.
But you need to serve, isn't it?
My lord, I have served, my lord. My lord, then fix a date, my lord. On that day, I will come back.
All right.
Hmm.
List on 9th. Stop. Let further notice to be issued upon the non-appearing respondents. Stop. Learned counsel for the state shall produce a CD on the adjourned date. All right. Next.
I don't want 25. 25 for the. My lord, for the condemnation.
I should serve the application upon the newly added contempt.
Who is the contemner?
My lord, the Commissioner, Siliguri Municipal Corporation. My lord, the order was passed 1.5 years ago, my lord, which is not being complied till date.
Yes.
My lord, after the order was passed by your ladyship, my lord, we have taken all these steps. Inspection notice was issued on 7th of May 2025. The inspection was done on 13th of May 2025. Inspection report was submitted on 23rd of May 2025. Hearing notice was issued on 11th of July 2025. Hearing was done on 23rd of July 2025. My lord, final order has been passed. Final order for demolition has been passed on 24th of July 2025. Date of demolition was fixed on 12th of November 2025. My lord, on 29th, we prayed for police protection, police assistance, but police was not available on that particular day. The next date was fixed on 19th of June 2025, but in the meantime,
26.
sorry, I didn't know. On 19th of June 2026, my lord, the next date was fixed. In the meantime, the POC got
The POC got dissolved
and the new commissioner was appointed. And within a period of 4
No
months.
appeal, no appeal. 1 minute. No appeal preferred against the
No
order of
appeal.
demolition.
No appeal.
Then it is to be complied with.
My lord, we are ready to comply, my lord.
My lord, that is just trying to avoid this proceedings, my lord, this circuit, my lord. Every time, my lord, they are doing this, my lord. Their engineer specifically is involved, my lord, in all these 3 contempts.
for the private party against whom this, I was not
Private party
Who has constructed the illegal construction over a high drain?
in a contempt,
Alleged,
the
it
court
is
is not
established,
required to
sir.
hear you. You are not a party in the contempt.
Don't mislead.
I was not a party to the, I am just submitting that we have already demolished that particular alleged portion that they are talking about. We have already.
Very well. The corporation people will go over there. They'll come back. If it is not there, it is not there.
My lord, next date of demolition has been fixed on 10th July.
My lord, that is completely to avoid this circuit, my lord. Thereafter, they will sleep for next 6-7 months, my lord.
Assuming it is to avoid the circuit. It is not that the court is running out.
My lord, but my
I'll
lord,
be available. You mention it, I'll place it in the
my lord,
next.
kindly, my lord, they have,
I'll place it.
my lord, order was passed in January 2025, my lord.
Thrice corruption went to demolition, then we all face a law and order situation. Police
Whose problem? Whose problem is this? Petitioner's problem?
No, this is not
Then?
the police problem. The police.
Why will you raise your voice? Appearing for the contemptor? No. No. Digunto? The direction passed. The order dated 30th April 2025 has not been complied with in its entirety till date. Stop. Learned advocate representing the petitioner submits that the unauthorized construction has not been demolished till date. Learned advocate representing the Siliguri Municipal Corporation submits that though unauthorized construction has been detected and order of demolition passed, but the same could not be demolished as police assistance was not available. It has been submitted that the next date of demolition has been fixed on 10th July 2026. Stop. Hearing of the contempt application stands adjourned till 6th August 2026. Stuff. The unauthorized construction shall positively be demolished prior to the adjourned date. Stuff. The Commissioner of Police, Shiliguri Police Commissionerate is directed to render all necessary assistance to the men and agents of the Shiliguri Municipal Corporation at the time of executing the order of demolition. Stuff. এটা কিন্তু আমাদের প্রিন্সিপাল বেঞ্চে চলে যাবে তাহলে লিখতে হবে let the records be transmitted চলে যাবে very well চলে যাবে An affidavit of compliance shall be made ready and circulated prior to the adjourned date. Affidavit of service taken on record. Now the BOC is there.
No.
How will you?
Administrator.
Administrator.
Yes.
SDO. SDO.
No, Commissioner. IAS.
IAS, not the post. What is the post? Who is holding the post of commissioner?
No, the commissioner has been appointed.
Commissioner
Yes,
appointed.
commissioner has been appointed, but as because the landed mayor, administrator.
All right, commissioner is there. All right.
I have not 26.
26.
My lord, after receiving the summons, my lord, they have finally passed an order, my lord, the commissioner, but the direction was passed 1 year ago to complete the proceeding within 4 weeks, my lord.
Now at least you get something to proceed for the next step.
It is upon them only, my lord. They have given order of demolition to the opposite party.
This is also demolition.
My lord.
Where is the order of demolition?
I need to go.
My lord, here what happened, my lord? The private respondents filed a civil suit. In the meantime.
No, not this.
Next one.
Now this order has to be executed.
Ma'am,
There is already an order of demolition.
It has been passed 2 days back.
Yes.
It will be executed. We will.
Please come. Learned advocate representing the petitioner submits that there has been delayed compliance of the order passed by this court. Stuff. The Commissioner, Shiliguri Municipal Corporation has passed an order, has detected the unauthorized construction and passed an order of demolition. Stuff. As it appears that the order of the court has been complied with, accordingly, the court is not inclined to proceed with the contempt application any further. Stuff. It will be open for the petitioner to take necessary steps for execution of the order dated 30th June 2026, passed by the Commissioner, Shiliguri Municipal Corporation, strictly in accordance with law. Disposed. Service is taken on record.
Deeply obliged.
My lord, one indulgence before your ladyship. My lord, may kind leave be granted that the affidavit of compliance be affirmed over here and be tagged along with the file. Otherwise,
In the earlier matter?
import the matter.
This matter it is disposed.
In the earlier matter.
Affidavit of compliance will be?
Affirmed in Jalpaiguri.
Yes,
and-
yes. No issues.
Filed before the registry so that. So that.
Yes, yes.
Deeply obliged.
No problem.
Okay.
You are not required to go there to Kolkata to get it affirmed. You
Deeply.
affirm it from here, you file it here, it will be transmitted. No issues.
27. My lord, at the foremost in this matter, we render our unqualified apologies before your lordship.
Not complied.
My lord,
Till date,
and my lord, till date, my lord, I will not raise allegation on commissioner in this, my lord. My lord, there is a person who is the engineer, my lord. he is in hand in glove with the private opposite party. My lord, a construction is made G plus floor and he is saying it is G plus 1. Engineer himself. Till date, my lord, no inspection report has been submitted to.
All right, the order dated report has been submitted.
To me,
What has
nothing
been
has been
submitted?
given, sir. Nothing has been given to me. No, it was to be given to me a year back, sir.
The order dated, what is the order? 1st May 2025 has not been complied with till date. A learned advocate representing the contender seeks extension of time for complying the order. Step next, in view of such submission, hearing of the contempt application stands adjourned till 10th September 2026. Stop. An affidavit of compliance shall be prepared and circulated prior to the adjourned date.
Deeply obliged.
Deeply ob-
Number 28.
28, I am for the petitioner, my lord. The order which is in violation is at page 13, my lord. Paragraph relevant pages at 14, my lord. Paragraph 5, 6, and 7. There was direction
Albazar
to
municipality.
yes, there was direction to pay the entire dues, but my lord, after receiving the
Contempt.
notice, my lord, on page 17, my lord, they have paid only 4 lakhs.
What is the total dues?
Total due was, my lord,
Is there any
yes.
quantification?
Yes,
10
my
lakh
lord. My lord, paragraph 1, my
33,570.
lord, of the order, 10,33,509, and my lord,
This is the allegation.
allegation
This is
that
the
the amount-
allegation is 10.
yes, that was the amount.
It does not have the sanction to clear the outstanding dues.
That was the admitted
Say
amount.
to please, no fund has been paid.
Therefore, interest was also levied. No?
Acha. The order dated 22nd December 2025 has been partially complied with. Stop. Let notice be served upon the contender.
May I come back on 8th, my lord?
So soon.
Yes, man. I'll be able to serve them.
9th.
Grateful.
Just on 9th.
Grateful.
Let notice be served. Pendency of the contempt application will not stand on the first day the order tax sheet approval. All right.
Grateful. Malad, may I humbly pay one thing? Malad, if the order be uploaded by today, Malad.
Why all orders are uploaded?
The first day when the one contempt was good, the order was uploaded after 2 days, Malad.
No, it will be uploaded. Daily orders are uploaded. So
Okay.
this is a direction of the Supreme Court.
Grateful.
Item number 7, personal matter.
For the petitioner, my lord, Mr. Ganguly is appearing before the court number 5, my lord. Kindly make it next circuit, my lord.
No.
My lord,
It cannot
this
be
matter
done.
is appearing for the first time, my lord, before this court, my lord.
Yes.
So, my lord, Thursday, then, my lord.
Maximum not today.
Thursday, my lord.
Accommodation sought
Because,
for-
my lord, yesterday matter was fixed on Thursday, my lord. And then if my lord grant me to Thursday, this matter be fixed, then my lord, it will be, my lord, taken, both the matter will be appearing, my lord.
You appear in court only on Thursdays and
No,
others
no,
why
no,
you
my
don't
lord.
appear.
2 matters, yesterday matter
So
was
what?
fixed, my lord, on Thursday.
Yes.
Then, my lord, if this matter be
No,
also
sorry. Accommodation sought for released on Wednesday.
grateful, my lord.
Your ladyship, may I kindly mention one matter before rising, your lordship? It's a principal bench matter. Petitioner is seriously a 71-year-old lady without electricity, your lordship. I'm praying for an interim order of restoration of electricity, your lordship. Kindly hear it from the circuit bench by video conferencing, your ladyship.
Cannot be done. The determination doesn't permit.
Your ladyship, the matter was listed before Honorable Justice Mithro, your lordship. Then it was released on the ground that my lady, kindly hear it, your lordship.